Good afternoon, Judge Koen.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm well, thank you, under the circumstances. Thank you.
Okay, all right. Thank you very much for availing yourself for consideration for appointment to the SCA, and thank you very much for coming to this interview.
Thank you.
We are going to ask you questions aimed at establishing to what extent you satisfy the selection criteria that have been adopted by this body for the selection of candidates for appointment to various courts. Everybody's here was to simply test your abilities and experience and competence and knowledge of law to see whether this body should advise the president to appoint you. Nobody wants to block you from appointment or anything like that. You may be asked difficult questions, but that's simply because commissioners want to satisfy themselves whether you should be appointed to the SCA. You do understand?
Yes, thank you.
Thank you very much. I will ask you some questions, and after that, I will allow the president of the SCA to put some questions to you. Thereafter, the minister, and commissioners that might have questions for you. We have got a lot of information on you, which you have supplied by way of the questionnaire and other documents. We are all aware of it. Everybody is presumed to have read the bundle, so we won't be asking you questions to cover everything. We'll only focus on certain areas.
Very well, thank you.
But everything will be taken into account in the decisions that are to be made. I see that in terms of academic qualifications, you hold a BCom and an LLB, and you got your LLB cum laude from the University of KwaZulu-Natal, and you have a diploma in arbitration. Is that right?
That is correct, Chief Justice.
Yes, and you, after varsity, you served articles, and you actually got admitted as an attorney, as a notary, and as a conveyancer.
That is correct.
Oh, but then you didn't practice much as all of those things, and you went to the bar, is that right?
I practiced for almost a year.
Yeah.
And then I went to the bar in February of 1988.
Yes. I'm sure there are many attorneys who would have liked to be notaries and conveyancers and use it rather than you taking it to the bar.
Well, I went to the sidebar with the intention of going to the bar.
Oh.
I disclosed that to my principal up front.
Yeah.
And I wanted to get experience at the sidebar.
Yeah.
Because I thought it was appropriate for a career at the bar.
Yes, yes. Okay. And then you practiced at the bar for a number of years, and you took silk in 1997, is that right?
That is correct. I practiced as a junior for 10 years, and then in November of 2007, I attained silk status, a senior status, yes.
Yes, and then you got appointed as a judge of the High Court in 2006.
November 2006, that's correct, Chief Justice.
Yes, that means that you have been a judge for about, is it 18 years?
17 years. On the 1st of November this year, it'll be 18 years.
Yeah. So you have had quite extensive experience as a High Court judge.
Yes.
Yes. Would you like to share with the commissioners the breadth of your experience as a High Court judge in terms of branches of law where you have given judgments?
Yes, I have a wide and varied range of experience as a High Court judge. Obviously, apart from the normal activities, chamber activities that a High Court judge is responsible for, petitions, the so-called mentals that need to be certified, chamber work. There's also the court work. across the whole spectrum.
Let me interrupt you, Judge Koen. Not the activities, but the branches of law where you have given judgment, like delicts, contract, commercial law, maritime law, coastal law, administrative law, patent law, that kind of thing.
Yes, I have across the wide range. Obviously, a lot of it is contractual. There are many intellectual claims that I've dealt with. There are administrative law issues that have arisen, insurance law, that is short-term and long-term insurance, including judgments on the interpretation of certain rules of long-term insurance. I have been involved in construction law. One of the judgments I referred to was a very large construction law matter. In years gone by, I dealt with some negotiable instruments when we still had checks, but obviously that's now a thing of the past. From my experience as notary, I think I had one matter once with protesting of a bill. Yes, I've had a wide and varied experience. Having regard also to the province in which I am a judge, we don't have the range of exposure to administrative law, like, for example, the Gauteng courts have, with the seat of government being here, or then the Cape Court, the Western Cape Court, with Parliament being situated there. But we do have many administrative law issues too, arising from disputes at municipal level. The KwaZulu-Natal province, as you will know, is quite a vibrant province. There are lots of competing interests. So we have regular disputes involving local authorities, control of local authorities, that kind of thing arising. And then just general disputes between man and man, neighbor law issues, or nuisance as they are called in some quarters. Yes, I think that's probably, trying to recall them from the top of my head, the main branches of law that have been involved.
Yes, and you have acted in the Supreme Court of Appeal as well.
I've acted in the Supreme Court of Appeal. I'm there at the moment. The current is my 7th time that I've acted there. Some of them have been for shorter periods. The one in particular was for a single appeal, which you would have noted from my questionnaire, and that was the matter of the Potato Board versus PwC, probably still the longest appeal, I think, in the SCA. It comprised more than 84,000 pages. So my one appointment, which ran from...
yes, no, that's fine. Tell me, your acting stints in the SCA, have they given you exposure to other branches of law that you might not have had been exposed to in the High Court?
Yes, they have.
Which ones are those?
Which
branches of law?
Well, when I say branches of law, I didn't write the judgment, but I've been exposed to trademark at the end of last year. It's a reported judgment written by a colleague of mine. Takis Biltong is the one party. Yes, certainly that's a branch of law that I hadn't dealt with previously. On intellectual property, I think I've only had exposure in KwaZulu-Natal once to a counterfeiting case. They don't come across our bench quite that often. But it's been interesting, and it's been challenging to get involved in other matters too.
Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes, my understanding from the doctrine of separation of powers is the clear division in a state between legislature, executive, and judiciary, and that they They operate in separate fields for a very defined purpose. Obviously, the legislature being there to create laws, to enact laws, the executive to give effect to administration, and then the judiciary having the task of adjudication. Now, in any constitutional democracy such as ours, there's obviously the question of review powers and testing both legislative acts and also executive acts from time to time on the basis of either legality or fairness, if it should qualify as a particular conduct should qualify as an administrative action as opposed to executive action. So to that extent, there is a crossover the line, but there must always be the responsible attitude of that there are separate fields of activity, and that one has to show deference to the other fields of activity or the other branches of the state, but at the same time not being, in the case of the judiciary, reduced to a situation of timidity, where if there's a wrongful act or an act which is illegal in the sense of offending against the principle of legality, that it be struck down as constitutional or then otherwise not be in accordance with law. It is, yes, I think it's that probably concludes my answer, yes.
Yes, and the rule of law?
The rule of law is the basis of our Constitution. It's stated in Section 1 of the Constitution. It underlies, and it's part and parcel, inextricably bound up with the principle of legality. It means rule by law, that is, that for every action there must be a legislative, a juridical base, a constitutional base underlying and supporting that particular act. But it's more than just a legality debate. It involves ancillary aspects to it, such as whether it implicates in a particular situation necessarily the duty to give reasons, or then to afford an opportunity to another party or be adversely affected to be heard. And I think it's been expanded over the years, and legitimately so, in an incremental fashion, to give effect to what I think the founders of the Constitution contemplated.
President of the SCA.
Thank you very much, Chief Justice. Good afternoon, Justice Koen.
Good afternoon, Judge Molemela.
Yes, just following up on the Chief Justice's question about the spectrum of work you have been exposed to in terms of branches of law, have you done shipping matters?
I've done shipping matters, not many. When in KZN we move between Pietermaritzburg and Durban, as you might know, as judges. And whenever I'm in Durban, the Durban court sits as an Admiralty court, and I've given judgments in matters. Mostly those applications pertain to the arrest of ships. That's what we find most. But there is one judgment, admittedly some time back, which I gave. I cannot recall the name now offhand, but it dealt with a shipping issue, yes.
Yes, thank you. You will recall, Justice Koen, that I once invited you to come and participate in an appeal at very short notice in unfortunate circumstances where a colleague had taken ill, and the matter had a very long history and could not be postponed, and the panel could not be collapsed to a panel of 3 because of the complexity of the issues raised in the matter. And so the matter had to proceed, and I contacted you after discussing the matter with the presider in the matter. And in my discussion with you, I warned you or forewarned you that if you agree, the presider had asked me to inform whoever has to come on board that they would have to sacrifice all their private time, no weekends, no private evenings, because the appeal was going to be heard within a short space of time. And you agreed to participate in the matter notwithstanding. Do you remember that matter?
Yes, I do. It's indeed the matter of SAPC. as you say, it was unfortunate that a colleague of ours had to withdraw at very short notice. It was set down now for recently, and I think I had just over 2 weeks, almost 3 weeks by the time the papers got to me to read the papers. I indicated in the questionnaire that that was the one matter in which I sat, although I was not the scribe, where the judgment was outstanding. And I just wanted to bring it to the attention of the commissioners that the scribe was in fact on JA, and the judgment in that matter is no longer outstanding. It was handed down on the 20th of March.
Yes, thank you very much. But going back to this matter, because I had called you at such short notice, subsequent to the hearing of the matter, I did have a discussion with you to ask you how you found the experience of participating in a complex appeal where the record is voluminous at very short notice. And I did say to you, I'm asking this question because I don't want to, in the future, be unfair to other colleagues if this has put you on the back foot. And you indicated that you coped, and in fact, your words were that if you were asked again, you would do it again.
Yes, no, I certainly would. It was not a problem. It was, as you say, there were no weekends, and it was full days reading with notes being made. But it was an interesting matter. It involved German law, and that made it so much the easier, I suppose, in a sense. But yes, I had no difficulty in dealing with it.
Yes. Thank you very much. So I note that you have been a permanent judge for 18 years. And prior to that, you were a practicing advocate, save for the time when you were an attorney. And your my calculation of your total years of experience is 41 years in the legal profession. Is that correct? More or less?
Yes, that's more or less correct.
Yes. So you are aware, Justice Koen, that the SCA has lost a lot of expertise, a lot of experience because of the retirement of very senior experienced judges and those who were elevated to the Constitutional Court. So would it be fair to say that at the moment the retired judges have to be replaced by very senior colleagues who are also very experienced?
Yes, I would go along with that. I think at the level of what comes before the Supreme Court of Appeal, it is vitally important to have experience, to be analytical, and to identify the crux of the case or the issues very pertinently and very accurately. And that is something which mainly, in my respectful experience, comes with experience.
Yes, so
there's no substitute. I think the American lawyer Oliver Wendell Holmes once said that the path of the law has been, in a different context, but the path of the law has been experience, not logic. And there's a lot of truth to that.
Yes. So are you confident that you have special attributes that would stand you in good stead if you were to be appointed?
Yes, I certainly would like to think so. That is the feedback that I've also had from the General Counsel of the Bar and the LSSA.
Yes, and my last question is this. You know that we work strictly in panels, which means that collegiality is very, very important. You'd also agree that judgment writing is a collaborative process or collaborative effort at the Supreme Court of Appeal, where not only do you have to give inputs on other colleagues' judgments, but you also get inputs that you must seriously consider incorporating. You agree?
Yes, indeed.
Yes.
It's the collaborative effort or experience which I think produces the better judgment.
Yes. Have you had any occasion where you delayed the delivery of the judgment, either because you did not give inputs at all, or you gave late inputs, or you delayed in writing a separate concurrence or a dissenting judgment?
No, I've never had that experience. I don't think I've ever had a judgment which I had to contribute to in the form of ascribing it, which took more than, say, 3 to 4 weeks. I have one judgment at the moment that I have to scribe, which I haven't completed.
Yes.
The matter was heard this last Tuesday, so it is now 6 days ago. I'm approximately 8 hours from finalizing it, and it will be circulated.
Yes. Now, in terms of your own judgment, would you say you are self-reliant, or have you also had to get assistance from other colleagues in terms of the substance of the judgment?
No, my judgments to date have certainly all been self-reliant. I work completely independently. I do my own research. I do my own typing, own formatting, and preparation of the judgment. It's only when I reach the point where I finalized it, with reference to the one that's outstanding at the moment, hopefully by tomorrow or so, that I would send it to the researchers just to check that I've got the quotations verbatim correct from the original text and that the case references are correct. But I don't take any, I don't request any input on the substance of the judgment itself. I work independently on that.
Thank you, Justice Koen. Thank you, Chief Justice.
Thank you. Minister?
Yeah, thank you, CJ. No question.
Thank you, Commissioner Steinberg.
Afternoon.
Good afternoon, ma'am.
Judge Koen. I was rather disturbed when you recused yourself from the criminal trial of former President Zuma, where, as I understand, the circumstances were that neither party had called for your recusal, but you put it on the agenda yourself and then recused yourself. I was concerned because our Constitutional Court has long said that there's a duty of the judge to sit. Hearing interlocutories or previous rounds in the same case necessarily means that the judge has exercised his discretion on the same case. It's a case of huge national importance, and where the judiciary itself has become the object of criticism due to the fact that it's been going on for 19 years. And by you recusing yourself, initiating that recusal, it of course set back the timelines quite significantly again. So I want to hear your justification for taking that unusual step. Thank you.
Thank you. May I deal with it at a few levels, please? It is correct that I raised the question of my continued participation in the trial, and it was, when it was raised, it was also adopted by certainly Mr. Zuma's team as an issue which they wanted to raise. So the question arose squarely. The judgment that I gave, I think, judges are reluctant to go beyond what's in their judgments. I think it speaks for itself, but if I may just recap very, very briefly, please, so you can understand my reasoning. The process had begun on the basis that there was a challenge to the title of the prosecutor to prosecute. That is in terms of Section 106, 1H of the Criminal Procedure Act. I was faced with an authority from the SCA, but also certain other authorities on what that meant. The case that was presented was, however, at a multitude of levels. When I say the case, that's the case by Mr. Zuma, or President Zuma. It was an attack on the basis of a narrow interpretation of Section 106, and whether a narrow interpretation was the correct interpretation or whether a wider interpretation should be adopted. Not only was it said that the prosecutor lacked the impartiality and the objectivity and therefore would prosecute at all costs, so to speak, But there were also a variety of other grounds that were raised, which it was said Mr. Downer had been involved in, which would disqualify him. So if you read my judgment on that, I dealt with the question of the title to prosecute and then these other grounds. Those other grounds included, for example, the whole CIA involvement, the Luciano secret agent, the spy tapes case and the involvement of the National Prosecuting Authority in that. It also raised, amongst others, towards the end of that argument, after the matter had been adjourned on one occasion, the issue of Mr. Zuma's medical records having been disclosed following an email having been sent from the correctional facility in Escort to the NPA, and the NPA then preparing, National Prosecuting Authority that is, preparing an affidavit, and that affidavit apparently or allegedly being leaked to Ms. Karen Morn before it was formally filed at court. That stage the proceedings are still before me. I came to the conclusion that I said there was nothing wrong, that the correct interpretation to be adopted was a narrow one, and that there was nothing wrong with the title of Mr. Downer to prosecute. But then following Spillhouse in the Constitutional Court, where one cannot just say, well, that's dispositive of the matter before me, I'm not going to deal with the rest. I then, at that stage, as I thought I was enjoined to do, and I think I am, dealt with these other grounds as well. And I said that those grounds were insufficient, and I didn't consider them to have any merit. Now, the reason why I'm telling you this long story is just to the build-up to understand the position. At that point, what was before me, and that I said didn't have any substance, was the alleged contravention of, I think it was Section 24 of the National Prosecuting Authority Act. And that essentially provided that it's a criminal offense for somebody in the National Prosecuting Authority to disseminate or to make available information that the National Prosecuting Authority has. So having said that, I found, on my view, there was no substance to that. What happened thereafter was that, in fact, a criminal charge was laid. The criminal charge did go to the Director of Public Prosecutions. There was a certificate of nolle prosequi. And I think by the time it came before, the hearing came before me again, one of the issues was that Mr. Zuma was now saying that Mr. Downer couldn't remain as a prosecutor, not because of any defect attaching to his title, but he was now also the accused in a matter in which the complainant was Mr. Zuma, and vice versa, and that created an intolerable situation. That was a novel situation. I'm not aware of any precedent on that, certainly in this country. And that was what was going to be argued before me, that there should be a further postponement, or alternatively then that Mr. Downer should be removed, because he was now not only accuser, but also accused in another matter. That issue centrally involved a finding on whether the private prosecution was well-founded. But I'd already previously found that the alleged contravention of Section 24 of the National Prosecuting Authority Act was without substance. I couldn't sit there deciding that issue as to whether Mr. Downer should remain as a prosecutor, where a criminal private prosecution was now on the cards, where I'd previously found that there was no substance to that criminal complaint. It is more important, with respect, that the judicial process be beyond reproach than finding oneself in a position of inevitable conflict as that would have produced. And I respectfully disagree with you on saying that the timelines were pushed out. It was raised at a point where the matter was, due to circumstances, going to be postponed in any event, because appeal processes were still being pursued in respect of my initial judgment to the Supreme Court of Appeal. From the Supreme Court of Appeal, when the petition was refused, it went for reconsideration, then it went to the Constitutional Court. Those processes were still ongoing, and the trial couldn't proceed. So no time was lost as a result of that. The matter was argued, and I gave my judgment, I can't recall the exact dates, but expeditiously within a very short period of time. So I regrettably have to take issue with you when you say it was pushed out on the timelines. It wasn't. Since then, things have developed, but yes, I'll leave it at that because those are issues before court.
Could I just follow up on this, on this issue, Justice Koen, if you don't mind?
Yes.
I read your judgment. There's only one reason why you recused yourself. It's because you had made a determination on the medical condition under Section 46, subsection 6 of the National Prosecution Act, National Prosecuting Authority Act. That was the sole basis. Now, what seems to me to have been happening is that the same issue that you had decided was being relitigated. And ordinarily, that would not be a basis for the recusal because you would simply affirm the correctness of your finding. And even if it is correct what you're saying to Commissioner Steiner, which is there was no specific pushing back of the time, there is still a problem. The Constitution says criminal trials must be finalized without delay. So the consequences, even if not intended, is that a trial that has already been delayed by 19 years is again going to be delayed because a new judge must be appointed and they must familiarize themselves with the matter and then they must read the record again. And yet you have been seized with the matter for 2 years, as I understand. So it's also a matter that I think it really does require reflection because the Constitutional Court in Sarfo said there's a duty to sit. In S versus Basson, it said sometimes you will make adverse rulings to an accused in the course of the trial, but that is not a basis to recuse yourself. So what you have done in this case, you've made an adverse ruling. The matter is then relitigated in a different guise. And then you recuse yourself on that basis. But that's precisely what S versus Basson said should not happen.
With respect, sir, I differ on that. The judgment is not just on the medical condition of Mr. Zuma having been leaked. It was on that. It wasn't the medical condition that was the issue. The issue was that it was information that was in the possession of the NPA, which they say shouldn't have been released. And on that, I had found that.
I apologize, Justice Koen. If you can look at paragraph 80 of your judgment, because you say you are not satisfied with any other of the grounds, but you are satisfied with one ground, which is this leakage under Section 46.6.
Yes. Yes, sorry, I don't have the judgment in front of me, but that's my recollection. But you say it's the confirmness of the correctness of my finding. The fact is, though, that from Mr. Zuma's perspective, this issue was going to have to be tried again. It's going to require a fresh determination. And I thought that it was appropriate that it should be done not by me, where I had expressed a very firm view previously on that issue.
Thank you, Chief.
Thank you very much.
Sorry, Commissioner Steinberg, I hijacked your question.
Yes, thank you.
Sorry, I hope that answers the question as best I can. I haven't read the judgment recently.
Thank you.
I can only say that I really am a little baffled by your answer. In that I think you, by seeing yourself as conflicted or having spoken on the issue, it might be seen to actually encourage litigants to relitigate the same issue on a different basis again and again. Rather than you did your job, you did it properly, and you could have done it again. Why there could be a reasonable perception of bias remains confusing to me.
Yes. Well, I've given my reasons. I've given the reference in the judgment and my interpretation of it. I can tell you that recently the judgment that I was asked about, the SAPSI judgment, led to a situation where the appeal succeeded on the basis that the judge, it was also a long trial, as you would have gathered from the record, should have recused himself. at a point which was about halfway through the trial. That entire trial has gone to waste. When there's a possibility of a trial of great magnitude proceeding where the suitability of the judge, whether he should or she should recuse themselves, had arisen, and it was dealt with incorrectly, as in the SAPC matter too, and the trial runs for 70 days or 75 days or whatever it may be, and then the whole process has to start de novo, because at the end of the trial, it is found that I should have recused myself, then I think the good administration of justice rather requires that we leave the judicial process beyond reproach, and that if there are reservations as to recusal, that one should then rather treat it as a proper case for recusal.
Thank you, Chief Justice.
Thank you. Judge Koen, I'm not going to be specific to the circumstances under which you recused yourself, but I want to say something about that last statement you have just made. With regard to recusals, isn't the position that we've got to strike a balance? A judge shouldn't just recuse himself just because there are some reservations. He or she is not sure, but she would say, I would rather recuse myself. And a judge shouldn't insist on sitting in a matter where they should recuse themselves. The proper balance is somewhere in between. Because on the one hand, you might say you are accusing yourself because there are reservations. You don't want a situation where after 7 days of trial, it's found that you should have recused yourself. You are trying to avoid that situation. But on the other hand, if we have judges who are too quick to recuse themselves, there may be litigants who would make use of that, take advantage of that. And then you could end up with the same situation where the administration of justice is brought into disrepute because judges are just too quick to recuse themselves. So I'm just saying, probably it might not be correct to say if you have reservations, you must recuse yourself.
No.
It should be more than that.
No, certainly.
You strike a balance somewhere. Is that right?
Yes, certainly. No, I endorse fully what you say. It is not, a recusal is not there for the asking. And I can assure you that I agonized over this issue for quite some time before I came to the conclusion which I did. Ultimately, it's a question also, I suppose, of conscience in a way. You know, I've placed myself in the position of that particular accused. If the judge had previously said that my complaint about Section 24, whatever the section is in the NPA Act, is devoid of merit, it's a lot of nonsense. And I now, in changed circumstances, and I don't necessarily agree that that's relitigating the same point, because now there is a prosecution, now there is a situation of accuser and accused. And he says, well, I don't want that same judge to decide it. Is that a reasonable apprehension of bias if you before a judge who has previously expressed that view? And that was my concern. And I agonized a bit both ways. It was not an easy decision.
Thank you. Commissioner Marumwakai.
Thank you very much, CJ. Good afternoon, Judge Koen.
Good afternoon, Prof.
Judge Koen, can I take you back to 2010? One of the judgments that you wrote, Shoprite Checkers versus Everfresh, it went all the way to the Constitutional Court, and it was a lease contract matter. You remember it. It's part of your papers. I just want to ask you, because in paragraph 23 of the judgment, you say, if the right carried the corollary of negotiating, then our law would require that it be in good faith. And I don't want to talk about the judgment per se. I just want to talk about the concept of good faith in contracts. And there's fight, I like to call it that, between the former judges of the Supreme Court of Appeal and some of the former judges of the Constitutional Court on the status of contract and how it can be influenced by concepts such as good faith, fairness, Ubuntu, and all those concepts. The way you viewed good faith in this case, I just want to understand whether your view has changed over the years, or what role, if any, does good faith as a concept play in or when parties are contracting, in any type of contract, be it a lease or say whatever contract it is?
Yes. It's a difficult question in the sense that since ever fresh, our jurisprudence has gone quite a long way. At the time when Everfresh was argued before me, it was peripherally on the level of, well, you must negotiate in good faith, that all contracts in South Africa are contracts of good faith. Initially at that stage, we even had insurance contracts, which was considered to be contracts in the utmost good faith, uberima fides. That has since changed, and the courts have said it's all contracts are just contracts of good faith. So at that level, yes. But the debate that I think you're referring to, if I may be so bold as to suggest that, is the different approaches to whether contracts should be enforced, whether on the basis of Ubuntu, whether on the basis of it being contra bonos mores, or whatever, that has been adopted at the Supreme Court of Appeal level and the Constitutional Court level. And you'll be aware, and I think that's possibly what you're also referring to, that there have been articles written by Judge Lewis, also by Judge Brandt, also by Judge Wallace,
yes, and Harams as well,
and adopting a narrower approach, a more formalistic, if you like, approach. These different approaches are actually very nicely summarized in a case note that was written by, I think it was Boonzaier, in the 2020 volume 1 edition of the South African Law Journal, specifically with reference to the judgment of the Constitutional Court in Botha versus Risch in O. And I think he makes the point there that it's not so much a case that the provision or the contract is contra bonos mores and is sought to be enforced, but that it's sought to be enforced in a manner which is not conducive, not consistent with good faith. You'll recall the facts in Botha versus Risch in O was about a certain percentage, I think it was 75% of the purchase price on an immovable property being purchased, having been paid on a property to be purchased. And then the Miss Botha, who was the purchaser, defaulted in making payments. And the breach clause was invoked, and when she didn't remedy her default, the contract was then cancelled. And the issue then arose, well, she'd paid 75% of the purchase price. She would have obtained a right in terms of the Alienation of Land Act to demand transfer against the balance of the purchase price being paid or being secured. But now, effectively, by invoking the default clause, the other party would be entitled to nullify that statutory right to demand transfer against payment of the balance of the purchase price. So the issue, and that's what's being motivated for in that article, is that one must have regard to the different competing rights. And if it's a contractual right that is going to undo, nullify a statutory right, i.e. the right to demand transfer of the property against payment of the balance of the purchase price, then that would be an unfair way. It's not a question of fairness and bona fides. It'll be an unfair way to defeat her rights, and therefore the unfairness arises from the manner in which the contract is sought to be enforced, rather than the contract itself being contra bonus mores. And it's in that context. It was in the period also of the Pridmore case, Bidika. I think Bidika at that stage was still making its way up to the Constitutional Court. It had come from Davis in the Western Cape Court. But I suppose the short answer is, I think there's scope for bona fides in the law of contract, but it has specific application, possibly more in the context of enforcement. But the last word, I don't think, has necessarily been spoken on this.
Thank you very much, Judge Koen. Thank you, CJ.
Thank you. That was the last question. There were no further hands. And also on the virtual. Thank you very much, Judge Koen. We have come to the end of the interview.
Thank you, Chief Justice.
Thank you for availing yourself once again. You are now excused.
Thank you, and thank you for patiently bearing with me. Thank you.